Good afternoon, and welcome to another King's Costs seminar, this time on the topic of artificial intelligence. Along with me today, it's Paul Hughes, who has a particular interest in this subject. And what we're going to do is take you through an overview of AI and start to think about how it might apply to the things that we do in practice. I should say at the outset, this is going to be big picture and very light touch, because this is a vast subject. It is a subject where you can easily go down the rabbit hole and you won't easily find the bottom. Having said that, what we're going to do is give it some structure. So we have an agenda of items we want to get through. In the usual way, we invite questions as we're going along, and that can be either in the chat or you should see a Q&A box at the bottom of your screen. So just let the questions come and we'll gather them up and do our best to answer them at appropriate moments. I should say at the outset that neither Paul nor I are computer scientists or data engineers, but then again, I'm reasonably sure that very few of you are either. So what we will do is the best we can to answer your questions. Equally and refreshingly, if counsel doesn't know the answer to a question, we'll tell you that too. We're going to cater through various points that we want to get over to about 5 o'clock. And what we'll do is the usual back and forth between Paul and I as we go through the various topics. So what we want to do is really set out what is AI and large language models. We want to talk about AI ethics, which are quite important in practice. Regulatory concerns and compliance issues, which are even more important in practice, unless you fancy being dragged over the coals in the divisional court. We're going to look at ChatGPT and other public artificial intelligence applications, of which ChatGPT may be the best known, but it's certainly not the only one on the market. We're going to think about how this can be applied in the legal context, and think about how it could apply in the context of costs, and in particular, the cost practices that we have. And then because we can't resist it, we're going to look at some thoughts about the future of AI and where this may be going in the next 3 to 5 years. So let me kick off then with something of an explainer first of all. What do we mean when we talk about artificial intelligence? Well, forget the Terminator, forget Battlestar Galactica, though both those shows are very entertaining. Artificial intelligence in this context means computer systems which are simply built to carry out tasks that would usually require human intelligence. In particular, what AI does is it recognizes patterns, it solves problems, it understands language that is used in the sense that it can form a best fit view of what language means, and it learns from experience in order to produce more informed outputs. But you can relax in the sense that AI doesn't mean synthetic life. It doesn't mean an intelligent machine. It doesn't mean a conscious machine. It has no personality and no independent will. It is basically a very sophisticated software program made to execute instructions using data and algorithms, but provided always by humans and made by humans. And in terms of where AI is happening, you may or may not be familiar with the extent to which it's already happening around you. It is actually starting to become embedded in our technology and therefore our civilization. So just to give you 3 examples, in medicine, AI can help with diagnosing diseases because you can have a software program which knows every single possible diagnosis due to a variety of symptoms and the products of scans, and can predict what disease someone has to a greater extent and with greater accuracy than any human doctor. It can help with epidemiological work because it can scan vast data sets to identify patterns which might be invisible to human analysis and would help, for example, in predicting and therefore preventing the next pandemic. In agriculture, it can boost crop yields, reducing waste through bringing more targeted precision farming and water use to bear. And it has a role to play in, for example, climate science through providing enhanced data analysis and modeling, which therefore guides disaster response. All of which is terribly interesting, all of which is very big picture. As to how we got to 2025 and the current state of the technology, this is a fascinating area. I want to only touch upon it very briefly, but in effect, we're looking at AI developing really from the 1950s onwards. We have periods where AI has fallen off the agenda because of the limits of technology or lack of funding or people moving on to more interesting things. But we then have, really in the last 15 years, an AI revolution, which I think certainly came to practice, to public view in November 2022 with the release of ChatGPT to the public. AI, in the sense that we're looking at it, is something which is sometimes said to be synonymous with what is called a large language model. And in essence, putting this as simply as I can, this is simply a very sophisticated software program which is trained on huge data sets, millions upon millions, billions, possibly trillions of amounts of text, books, articles, websites, the entirety of the internet, then trained further and then is facilitated to take someone's instructions and produce an output using all the data that it has to hand. I don't think we need to go into the detail of the technology. You'll see how this is reflected in the notes and slides that are going to come out to you. But what we can say is that the potential of this technology is simply vast. And it's discernibly vast because of the way it's already being reflected in our economy. If you take just one example, NVIDIA, or NVIDIA, as some people would call it, the well-known chip manufacturer, which produces virtually all the chips used in the world for making computers, is now at a valuation where it constitutes 8% of the entire American stock market, the S&P. And the consequence of that is that a large part of our economy is already afloat on AI, but it's going to get even bigger as the full potential of this technology comes to play. It's also right to say that many of the companies which are household names, such as Apple, Google, Microsoft, are investing billions, tens of billions in this technology because it has the potential to become embedded in virtually everything that we do, like electricity or like the use of iron. And if that's right, if that bet proves to be the case, then people who have invested billions will probably make trillions on the back of it. So it's very exciting. And of course, it's, as I would say, something that's going to come to play in the law. And that's something we'll be looking at. But before we go on and consider the legal aspects, I'm going to pass the baton over to Paul to give you his view on this.
Yeah, thanks, Andrew. A few other things to add really about when I've done research on AI, I am astonished at, frankly, how embedded it already is in our sort of social architecture and in the sort of everyday life that we carry out. I mean, you think back, this seems like a long time ago now, but back to Alexa, Siri, the start of Alexa, Siri, Google Assistants, all the virtual assistants, that all become part of everyday life and have done now for a long time. I think probably a decade, Amazon Alexa. A little bit after that for Siri. But then also recommendation systems like Netflix, Spotify and Amazon Music, how they know what you like. They know what you like because there are AI algorithms in the background telling them what you like and how long you hold your pointer over a particular track. Navigation, smartphones, Face ID, etc. All of those everyday uses all involve AI and obviously social media. You will know that if you've talked about sausages in the morning, you'll get a picture of a sausage at lunchtime. That's just one example that I pulled out of somewhere, but it applies to pretty much anything that you discuss. Obviously, in business and finance as well, fraud detection, customer service, chatbots, they're all powered by AI, along with marketing, sales, and trading. And trading, of course, itself is something that is hugely impacted by AI, with patterns of candlestick patterns and the like. So we have an interest in recognition of likely drops and likely runs in the market. Also, industry and engineering, energy management and construction, and of course, autonomous vehicles. You all know about the robotaxi that Tesla is seeking to implement, as well as, of course, our own sector, which is the law. Now, the practical benefits we'll look at for lawyers, but of course it lies in drafting, summarizing, building chronologies, translation and simplification, and research. Those are the large aspects of it. But as well as looking at where we are, it's worth a moment just looking at where we're going to go. Now, Andrew's mentioned sort of the Mag 7 names, the Microsoft, Apple, Meta, etc., and their investment. Now, they're investing billions of dollars, in proprietary hardware, data centers, platforms, bespoke tools to enable their own businesses to move forward. But it's worth noting that is not going to stop. The capital expenditure, or CapEx, of these companies is increasing. For example, Amazon's increasing 27% year on year on AI. Microsoft, 80% year on year on AI. Alphabet or Google, 43% on AI. So don't expect it to stop. And so it isn't something that is the emperor's new clothes and simply won't be followed through. It undoubtedly will be, and we'll probably finish with this, part of your practice in due course. But don't think of it, as Andrew said, don't think of the large language model as a thinking machine. It is in effect a giant prediction engine. It could be looked at as autocomplete on steroids. It assesses probabilities of what are called tokens being the correct, which effectively is text that's input into the computer, being the correct next step. And that, although that sounds like a simple single step process, it's done billions of times over. And every time it gets it wrong, it adjusts the parameters so that it gets it right. And so the sheer vastness of the task that these machines or these models carry out is something that is difficult to comprehend in terms of the repetitive and quick nature of it. So that's what they are. How do we move forward without this being unchecked and left like the Wild West? Well, we have to follow some ethics, and the AI. This is the next topic we'd like to sort of address. The next topic is AI ethics in practice, and that, in essence, is those moral principles that guide the development and the deployment and use of artificial intelligence. And of course, as lawyers, we're very familiar with ethics, usually in line with regulatory guidance. And it's important in legal practice because, of course, legal practice is generally built on trust. And so our clients need to know that the processes that we have in place ensure that the data that they have is safe, the advice is accurate, and our decisions are accountable. And there are some core principles to those. The main being transparency. So you need to make it clear when AI is used, or we should make it clear when AI is used. Accountability is another, which is that as lawyers, we remain responsible for the use of AI and the outputs that we get from it by virtue of the inputs that we put in. Fairness. So that's a key principle to AI ethics, to ensure that there's no discrimination or bias, either instigated or reinforced by virtue of what we put in. So if you put in bias prompts, then you might get a biased prompt out, and that's contrary to the principle of fairness. And of course, data security and confidentiality, which will be probably top of most people's priorities when they think about ethics and how they can properly use AI without there being a breach of those principles. The final one of the final ethics principles is, of course, that there is a societal impact from AI, both societal and environmental. And you may have heard a lot about the amount of energy that AI centers take to use, but it really is staggering, because it's estimated that a frontier large language model like ChatGPT 4 or Gemini or Claude take weeks or months of continuous training on tens of thousands of GPUs. And so to train GPT-3, it took as much energy as it would to run 120 homes for an entire year. And apparently GPT-4 was to take 10 times as much as that. So the amount of energy usage is obviously something that is talked about generally environmentally. But one statistic that I found was that by 2030, AI and data centers could account for 8 to 10% of global electricity demand, and it's currently 2%. So that gives you an idea about the scale of the energy use. Now, I'm no soundbox for the Green Party or anything like that, but it is interesting to see that. But that's one of the other sort of facets of the core principles of ethics. I'll just hand over to Andrew now to talk about what perhaps the UK AI ethics framework is and how that fits into the regulatory concerns for the SRA and the BSB.
Okay, I think as lawyers, we tend not to talk about ethics enough. And the reason that it matters is because this technology, for all its tremendous potential to do good and to advance the cause of access to justice, has the potential to do tremendous harm. And let me just give you a few examples of the harms that can emerge. One of the pieces of homework I'm going to give you is, after this seminar, I'd like you to go to whatever AI application you have access to, Copilot, ChatGPT, whatever. And I'm going to ask you to ask it to simply create a picture of a lawyer for you. Is anyone able to guess what the sex of the lawyer will be shown in the picture? What gender will be on display? Well, I think you'll probably be able to put a fair bet on it that it will show a man. Anyone able to guess what the ethnicity of the lawyer that you simply asked it to create will be? I think you'll be onto a good bet that it will show a white person. And the reason for that is because any AI application is only going to be as good as the data that's put into it. And so what it will do is give you the picture, the stereotype of what it thinks a lawyer should look like. Give you another example. If you ask it to show you a picture of a clock face, I'm reasonably sure it will show you a picture of the hands at 10 to 2. Why does it do that? As far as I can tell, simply because most pictures on the internet of clocks show clocks at 10 to 2. Now, again, what that illustrates is that it goes with the flow of the majority of the data that it has to develop. Where it becomes more malign than that is, for example, when the government in the COVID years deployed an algorithm to allocate school children's grades at GCSE. And because it was an algorithm, it looked to replicate the pattern of preceding years in the pattern of the current year. And so it very sensibly gave all the worst grades to the kids in the most deprived schools in the most deprived areas. And it gave all the best grades to the kids in the schools in the affluent areas. And this is why, when this came to light, it led to columns of school children marching around London, bearing placards saying, "Fuck the algorithm." Now, all of these things are only examples about how insensitive deployment of AI systems can perpetuate stereotypes, discrimination, or biases. The other aspect is, of course, data confidentiality. If there is one thing I want you to take away from this seminar, it's don't put your client data in ChatGPT or anything similar. The reason for that is that these systems are famously insecure, and there is a terrible danger that your client's data could be accessed by others, or in the very least would be used as training material for these applications. And so when you consider how the regulators are quite ready and able to crucify lawyers who leave their briefcases on trains. You can see the horrible potential if you spill your client's data and information over the internet, even though you don't anticipate that that is what in fact you're doing. Now that then brings us in to the fact that the ethical concerns underpin the regulation that we're all subject to as lawyers. I can see we're starting to get some questions. Obviously some people are having a go already at producing pictures of lawyers as we're speaking. And again, it'll be interesting to see what we get. Somebody, I think, has made the point that some clients are using ChatGPT to produce translations of their document. And in a sense, the translation capabilities of these is a really good thing. But of course, it depends upon what you're translating. And if you're putting in privileged documents to be translated, then that is going to be a very bad thing and something which you need to warn your clients about. But coming back to the thread of where we're going on this, regulation in this area has exploded. And if you are a solicitor, you need to be aware of the SRA standards on AI compliance. We've helpfully put a list of those together and the things you need to be looking at. And if you're a barrister, we've again put together a list of what you need to be looking at in relation to the standards and the guidance that we as barristers are subject to. And I think the point has now been reached that you cannot be in ignorance of these things. They cannot remain in the slush pile to be read when you've got a quiet moment. This is unfolding around us. And in particular terms, what we've seen this summer is a slew of cases reaching the divisional court in relation to particular problems which have arisen through people using ChatGPT or something similar to that in order to produce their legal work. What can happen when you do that is, leaving aside the data breach and confidentiality concerns, you can get the benefit of what we call hallucinations. Can I just explain for those who don't know what a hallucination is? As Paul has explained, these are prediction machines, which means that they don't actually think about what they're producing for you. What they're concerned to do is to find the best fit answer for the question that you've asked them. And they get it wrong. So if they are asked to find authorities to support a particular proposition, what they will do is work on the assumption that there are authorities to produce that particular proposition. And if they can't find the real ones, the accurate ones which apply, they will make them up. And they do this a lot. And even if you try to steer them and narrow their performance so that you're putting anchors or tent pegs in to focus the output, then that might not work, or it might not work in part. And this in turn has led to a point taken consistently by the regulators that if in any shape or form you are using ChatGPT or something similar for your work and are able to avoid the other strictures about client confidentiality and data protection, you must verify each and everything that they do. Because otherwise, the consequences are that you turn up in the High Court with a skeleton argument full of 25 fictitious authorities. And if you then pose the question, well, what would happen in those circumstances? The short answer is very bad things. So let me pass the baton over to Paul to talk a bit more about these regulatory concerns.
Yeah, the first case to address this was a case called Matter and Avianca in the US, and this was the first authority of any jurisdiction, I think, that addressed the problems that can arise. And the counsel drafted a pleading, or lawyers drafted the pleading acting for a claimant against Avianca Airlines in a personal injury case. And they effectively included a number of non-existent precedents. They were sanctioned by the court because the AI, whichever model they were using, hallucinated, as Andrew explained. And they were fined $5,000 and told to inform the hallucinated judges that were referred to in the hallucinations what they had done. But it's not just that cautionary tale from over the Atlantic, but as Andrew indicated, we recently, and certainly, well, this year, I think there were 2 cases this year, one called Bandler and the SRA, and another which I'll come on to mention in a moment, in which there were, on that occasion, 25 cases that were cited. Two additional cases had a tenuous link to real existing cases. In an application by a lawyer again for an appeal against the SRA striking the lawyer off, the application was dismissed for being an abusive process. It was argued that, in fact, it was a Google search rather than any AI LLM. But the reality is it doesn't really matter, because Google has had AI under the hood since 2015, and it's now only now and since 2023 that when you search on Google, it comes up with the AI overview, which I think probably is everybody's sort of first port of call to see if, certainly mine, to see whether the Google search can help without going down the one of 10,000 or 10 million other hits. The regulatory, those sort of telling tales from both here and in the US obviously bring into focus I hope I'm not breaking up for everyone, but hopefully bring into focus the principles firstly the SRA and then the BSB. Now, the professional duties under both the Bar Standards Board Code of Conduct and the SRA Code of Conduct both still apply with full force when using AI applications. The principal parts of the code that you'll be concerned with from an SRA point of view are competence. So 3.2 requires competent service, including understanding the AI outputs, a prohibition against misleading the court by putting hallucinated citations in, and Rule 3.5, which makes solicitors accountable for work done by others on their behalf. Those are clear focal points for using AI in the course of your practice. And I can't reinforce enough how important it is to verify any reference. I have undertaken a lot of legal research with the assistance of ChatGPT, and I think the hit rate of it being accurate is less than 70%. So 30% of my work might well have been citing hallucinated cases if I'd followed it without verifying. And it's important to make sure that is done. Of course, you can't litigate for litigants in person. I think one of the points that was just made was, I have a litigant in person I've been against the litigant in person who's drafted complex applications like Norwich Pharmacal orders, and cited a lot of authorities that have been hallucinated. They're being kicked out properly by the courts, and then you've got a cost order that you can't enforce. Well, I am afraid that the public access to all of this wonderment is likely to also be its Achilles heel, because it will make things much easier for litigants in person to draft those kinds of applications. Of course, they're not subject to the sort of code of conduct that solicitors and barristers are. What the solution for that is, I don't know. It might be helped by a direction by the court, as may be the case in due course. It's not there at the moment, but it may be in due course. And I'd be interested to know what Andrew thinks about this. That you have to disclose if and to what extent you've used an AI model in drafting any or all of your documents. That might alert any judge that's about to hear the litigant in person's application to the fact that there might be hallucinations. You'd hope that the regulatory oversight on the part of barristers and solicitors would sort that out. But for a litigant in person, it's not so easy. What do you think, Andrew, about how you could stop that problem, if you can?
Well, I think the first point is detecting when AI has been used. And often there are a lot of tells that it has, because something is being written with bullet points, numbered paragraphs, and the use of the M dash, which is an Americanism which finds its way into English prose by way of alien intrusion. The point really, I think, is not whether they're using AI, but whether they're using AI accurately or not. And I think the problem that follows is most of the time they're not, because of this problem of hallucination and so on. But if litigants in person are doing this, then to a certain extent, there's nothing to be done about it, apart from to sanction them after the event, because in effect, the system has no filter to prevent them from doing so. What is causing me more concern at the moment is not the litigants using AI, it's the judges. And I'll give you two particular examples from my own experience. The first one was when an application for permission to appeal to the Court of Appeal, in one of my cases, was refused by Lord Justice Birse, who used AI in order to write the reasons for permission, refusing permission. I know about this because he told the Law Society Gazette what he had done, and I was reading about this the day after we got the order. So far, so good. The second point was I had another case earlier this year where a circuit judge had plainly used ChatGPT to draft the order refusing permission to appeal because it was there, numbered points, bullet points, M dashes all over the place, and 3 pages of reasons. Going to the oral application for renewed application for permission to appeal, he changed his mind. What I didn't ask him, for various reasons, is whether AI had been used to draft the initial refusal or whether it had been used to make the decision, because there's quite a distinction between the two. This is only going to become more common because, let's face it, judges don't like writing judgments. It's the most tedious part of the job, writing a legal essay, which everyone's going to criticize and pick holes in. So more and more use is going to be made of AI by judges. And now there's judicial guidance, which is actually referred to, I think, in the Ayinda and Arun cases, which we've referenced in the notes. But this is something that you need to be aware of. You'll be getting it from both sides, the litigants on the other side, and possibly the bench too.
Yeah, I think just about that, the Ayinda case, that was a divisional court decision in this year. It's the first time that there'd been formal guidance. It's worth just making a quick point about what that guidance said. That was a case in which there's an application for judicial review drafted by a barrister, and there were 5 cases that were used that were effectively fake. Whether they had been hallucinated by ChatGPT or another AI model was left sort of in the hanging as a question. But it doesn't seem that on reading the judgment there was any alternative other than the lawyer creating the cases. These cases were high court cases, high court authorities and court of appeal authorities. Although AI wasn't accepted to have been used by the barrister, it looked like the only thing it could be. Anyway, the higher divisional court made clear that there was a responsibility on both solicitors and barristers to make sure that their submissions were right. It was professional misconduct if they were not. And that there's a self-reporting mechanism that exists for these kinds of errors. And both the solicitor and the barrister would have to report themselves to the SRA and Bar Council respectively. So and in fact, the court went on to say that there are serious implications for the administration of justice and public confidence if those sorts of if cases come before the court where there are fake authorities. That probably won't surprise you, but it's an important point to recognise that all legal representatives have a responsibility to verify, and whatever the pressure of time, there is no excuse for it. So it is important from both barristers' point of view and solicitors' point of view to adhere to those tenets in the solicitors' code of conduct, and of course in the Bar Council's Bar Standards Board, the code of conduct for barristers, to ensure that the regulatory aspects of the use of AI, which of course mirror in many ways the ethical aspects that are relevant for the use of AI in general terms by civil servants and the like and others. But they're mirrored in the regulatory aspects of the legal profession. Andrew, I think I'm going to pass to you to look at where we are now with ChatGPT. I suppose it's the most popular and well known because it was free and very well marketed. It still is free. I suppose you could pay for it, but it still is free for many people that use it, not on a particularly frequent basis. And just explain really where we are now and how that has perhaps changed general public life, but also in particular regard to the legal life that we lead.
Yeah. I think that ChatGPT is a good place to start, Paul, because it's the best known of the open applications. It hit the public sphere in November 2022, and it's been through several iterations now to the most recent one, which is ChatGPT 5, which was released in August. It's an incredibly powerful tool. You can't break it, have a play with it, and forego coffee for a week if you have to buy a £20 subscription to get the higher level of functionality and play around with it. Can I tell you what its values are? The first point is that ChatGPT is a universal key. If you want to translate something from one language into another, it will do a cracking job, much better than Google Translate. If you have got something where you have an impenetrable and dense instruction manual and you want it written in language that a 12-year-old can understand in a non-technical way, ask it to do that, upload the technical manual, ask for that summary a 12-year-old can understand in non-technical language, it will produce it. If you want to go to the other end of the spectrum and produce something extremely complex, like learning how to build a website, get it, again, to give you a list of instructions from A to Z, and then you just follow them. I have tested this thing to destruction by asking it to give me a complete set of blueprints for rebuilding the Great Pyramid of Giza in Nottinghamshire, which it has been happy to do. It can't produce the CAD drawings, but it can produce all the instructions for them. It can consider how local planning policy will apply to what I'm proposing to build, and even will tell me how many slaves I'm going to need over the next 5 to 10 years in order to ensure that the project remains on construction. I emphasize that, but this is to give you an idea. If there's information out there, ChatGPT will pull it all together and string it together for you in whatever shape or form you need that output. It is also an imagination machine. You can use this thing for wargaming. You can ask it about cases. If, for example, you're working at home and you don't have the facility to have water cooler moments, or you don't want to phone a friend when you've got a point to discuss, provided you're not putting anything sensitive, confidential, or would involve data breach into it, you can do what the hell you want with it. And you can use it to war game scenarios. You can use it to create ideas. You can ask it to test weaknesses. You can build business plans. You can ask it to provide strategic analysis of what your competitors are doing. And it will do all these things for you. Where it becomes particularly useful, however, or where it has the potential to be useful, is, for example, in things which are at the periphery of legal practice. Anything that you want to do, like write articles, write blog posts, put a seminar together, you can use this or related applications to do, and it will speed up the process by so much. If we sort of drill down from what ChatGPT can do, as I say, it can't do the core elements of lawyering. You have to go to secure environments for that. You can use Microsoft's Copilot. I have a subscription to Copilot. It seems a poor, shabby little thing compared to what ChatGPT can do. But I use it to save time in doing things. And I also use Copilot when, for example, I have Teams conferences where I can get the Teams app to record the conference as a video. I can get it to create a transcript of the conference, and then I can get Copilot to summarize it and pull out the action points from it. So it's already starting to make an impact. But what we will probably see is a shift away from ChatGPT to what I call proprietorial solutions, such as Protégé, such as CoCounsel, such as Harvey, which will do the heavy lifting of legal research on existing databases, reducing the possibility of hallucination because they're using closed databases, not the World Wide Web. Document analysis, where you can get it to examine patterns and pull dates together, create chronologies and things like this, again in a secure environment. Drafting, where you can actually create documents which don't involve client or do involve client information within a secure environment. And of course, the facility not only for things like transcription, but administration. But I think if you're new to AI, get yourself a ChatGPT subscription for a month, play around with it and test it to destruction. I think you'll be pleasantly surprised by just how much it can do.
Yeah, I'd agree with that. I think certainly a lot of my solicitors are now using it in obviously, as long as there's if I'm going to sort of caveat everything with this, make sure that there's no sensitive, confidential or data breach. But if you can ensure that, and you can do that with certain contractual documents, which I think Andrew and I discussed, a lot of it is boilerplate, where you can certainly anonymize a client. It will draft a contract for you or assist in drafting a contract for you. In circumstances in which it will effectively save time. So that the power of ChatGPT and the like is that it will it's effectively a legal assistant, or you could treat it as a legal assistant. It saves umpteen hours worth, or potentially umpteen hours worth of time, and therefore potentially save money. Although we'll come on to look at whether it does, and if so, how it should be viewed in saving money in a moment. But the conference note, the conference note is being dictated and then summarized, I find very useful, not least because it reminds me of exactly what I have said in conference and transcriptions of conference and the like. Sometimes the transcriptions of the conference can be many, many pages long, but they can be summarized. Again, it's just as good at doing that. And I do find that helpful in terms of going forward with the case. Obviously, converting speech to text is one thing, but the legal research subject to verifications another. Analyzing disclosure, again, probably has to be done in a closed environment. They can be expensive, but that will probably end up being worth the time, given the extent of disclosure that's offered, that you would yet tend to engage an AI service for summarizing witness statements, summarizing anything, long or short. I find it very, very useful. And one of the questions that we had, there were two questions, Andrew. Firstly, was does our firm have an AI policy, or I suppose our chambers does have an AI policy, and I think as far as regulatory concerns, it's sort of moving, just taking a step back to regulatory concerns. One of the points that one of the steps you might want to implement in the event that you do use AI is to have a policy, and that would be an appropriate starting point, and to have an audit trail in relation to any work that you do with the assistance of AI, so you can show how it's used. And so that engages that key tenet of the Solicitors Code of Conduct being transparency. So know that you can use it, competency, and say when you have used it. That in the event of any sort of SRA audit should help. So that was one of the questions about should you have an AI policy? I think if you're in a legal firm dealing with AI, if you don't have it now, then you should do, because you will inevitably use it. And the second one was, have you tried Harvey collectively? If so, what do you think? Well, I haven't tried it, but I've asked you, Andrew, whether you have and whether you find it.
Yeah. I think there are two really interesting points there. The first point is that the use of AI is a massive regulatory risk for solicitors, because even if you think in your firm that you're not using AI as a firm, the individual solicitors and fee earners working within your firm are using it all the time. You just don't know what they're doing. And the danger is that they're going to cross these ethical and regulatory lines, and you're going to end up with a data breach situation on steroids, or hallucinated authorities going off to court in a set of submissions or something of that nature. So this is a real crunch point, I think, for the profession, because there's this lag at the moment between what the technology can do and people's awareness of its limitations and regulatory response. In terms of particular legal use cases, I've used LexisNexis, and the earliest iteration of it was rubbish. I'm told that Protégé, which is the new iteration, is much better. I'm looking forward to getting to grips with it. Co-counsel seems to be expanding, but I haven't done a trial of that yet. And a good friend of mine is going to show me how Harvey works next week. So I'm looking forward again to getting to grips with that. But the reality of the matter is that these applications are changing, and the marketplace as a whole is changing. You will see bespoke applications, trial view, something I've seen advertised, which could potentially be extremely useful at all. But they all come at a price, and you are paying that premium to have a closed system with a closed database and no danger that someone's going to be able to see your secret notes at some remove over the internet. So I think that, you know, it's a really fast moving space at the moment.
Yeah, I think you're right there, Andrew. I think if we just we probably move on to talking about the use of AI in our particular area of practice, in costs practice. And it seems to me that whilst we've talked about the AI applications in general, legal practice, it's worth narrowing that down to our own area. Now, it seems to me that costs practice is a really fertile area for the use of AI because of the volume of repetitive data. So in a bill, or sometimes in points of dispute and replies, but that's no criticism of those who draft those or when I've drafted them. There is repetitive data abundantly in precedent, in both in the precedent S's that you see and in old-fashioned, old-style paper bills. So I think that AI can help, or will be able to help practically with costs in terms of obviously drafting bills, but although we have that already, I suppose, with Costmaster and the like, where there are programs that take diary entries and create bills from them, and so we'll all be familiar with that. Although it's likely that will become much more sophisticated, I suspect, with the introduction of further AI models onto it. Drafting points of dispute and replies. I'd anticipate that AI will be very helpful. Again, we have to sort of caveat it with it being a closed system, or as long as you can anonymize the data that you put into ChatGPT, because it should enable you to, as opposed to, instead of having to filter down the arrows and choose the correct columns to filter in order to isolate the data that you want to see, it should enable you to do that by way of prompt engineering, so that you can identify the relevant parts of the bill and ask ChatGPT or an AI model to isolate and recognize patterns of inefficiency or patterns of efficiency for the concept for arguments on principled arguments like proportionality. Also, there should I think it's probably going to help with not only mining bills of costs for those sorts of patterns, but also for recognizing where there's been overspend. And I'm hoping that will lead to a greater and more rapid recognition of when solicitors overspend, because applications to vary will be made more promptly, or there'll be the reins put on cost in order to prevent the overspend. That's not something, it seems to me, that in my experience has happened a great deal to date, but hopefully will do in future. But of course, there's no substitute for a lawyer looking over anything that it's very much a first step. So that's where I see, in terms of the sort of costs pleadings aspect of cost practice, there being increased use of AI, and of course drafting skeleton arguments, legal research, etc. I think there's an interesting argument, or an interesting point that can be made, that in fact it's going to revolutionize the way that we bill, and or rather the way that we criticize or consider the way costs are billed. I'll just pass on to Andrew to make a few words on that.
Yeah, I mean, I think there's a lot here, and sort of taking them really in the sort of order that Paul's identified them. When you get the slides from this presentation, bear in mind that they took us 2 minutes to create. And the reason for that was that we used an AI application to pull through a lot of data from other sources. But it gives you an indication of the power of data management from a closed system. The second point is that in terms of where AI is at the moment, we're only at the beginning. I think the state of AI, if you want the analogy, is similar today to the state of television in the 1950s. It's only going to get better, but it's going to get better a lot more quickly than the television technology developed. I've used Copilot to try and analyze bills in Excel, but I find it a bit clunky, and I don't like the Copilot interface in any event. And if you know your way around the spreadsheet and how to make a pivot table, you can actually probably do it as quickly yourself. With other applications, I certainly think that there's going to be more scope to deploy them. There shouldn't be overspends on budgets now, because you will be able very quickly to have software solutions which monitor time done against time budgeted. You're going to have, some of the grunt work undertaken by AI. You'll upload skeletons into Copilot or its equivalent, ask it to identify the authorities, and then get it to pull the authorities through in the appropriate version of the law reports. I actually already use Copilot to assemble indexes for bundles of authorities, but it can't quite go the next step yet into pulling through the PDFs into a bundle. And I think if we go big picture here, there are lots of applications that we can see. For instance, data analytics. Every so often we get a new version of the SCCO guide, and it tells you which forms to use and points of that nature. Imagine if you had a guide which told you what the spread of hourly rates is that particular judges give in particular flavors of case. How useful that would be. And it would be possible, I think, to, as if you've got the data, to start pulling that sort of analysis together as to where predictive analytics could take you. If we zoom out from costs and look at a couple of other areas I have some familiarity with, take, for example, credit hire claims. If you've ever touched upon a credit hire claim, you know it's all about the rate. Well, now you have software solutions which are laced with AI, which send out web crawlers collecting millions of hire rates from websites all over the country, 300 million lines of data or whatever. And they can use this to produce 70-page rates analysis reports, which can be said to nail effectively what the appropriate rate is for a credit hire claim. Look at it from another context. If you're in the catastrophic personal injury world, insurance companies and compensating parties are sitting on huge troves of data over decades worth of cases, which they could use very quickly to pull together analytics, which in effect would mean that instead of waiting 1, 2, 3, 4 years from start to conclusion of a case, they would be in the position to make a decent, well-judged, data-based offer on the average within a matter of months. So all of these things we can see just over the horizon, really, and potentially going to come through within a time frame of our professional lifetimes. So those are the points I wanted to make. The only other point which Paul touched upon, which I think is very significant, is this: the end of the billable hour is here. In a sense, the billable hour has been shot through the heart, but it's still walking because no one's told it that it's dead. But what I think we're going to have to grapple with, and quickly, is how you charge someone for the value you give to their case, as opposed to the time that you spent on this. And it seems to me that that is going to be a big issue in the next couple of years. Paul, if I pass the baton over to you.
Yeah, I'd agree with that. And of course, there's an inherent dilemma here, because you can be criticized for, obviously, if you choose to use AI and adopt it in your practice, then you've got to navigate regulatory compliance. You've got to deal with the ethical sort of framework. You've got to recognize that you are accountable for anything that comes out that has had the magic hands of AI touch it. And you could be the subject of criticism if you don't abide by all of those processes. And you might say that that in itself adds to the time. But on the other hand, it is also a truism that in the event that it might not be the case now, but nor was it in COVID times, before COVID, when you didn't adopt the cost-saving tactic of implementing video technology to do Teams conferences or Zoom conferences. So it may not be a criticism that is a viable criticism now, but it sure as eggs are eggs will be, that in fact, instead of spending 3 hours on legal research, insofar as it's legal research that will be recoverable, which it might not be, or 3 hours, 4 hours, 5 hours drafting a document that with the assistance of AI could have taken minutes, you're likely to be the subject of criticism from a cross-party criticism for not using AI. And as AI becomes more endemic and used for greater and more detailed things, I think that those criticisms are like you all remember not being criticized at Detailed Assessment for having a in-person conference in 2019, but then in 2023, after Zoom blew up and Teams was well used, the arguments started to come. Why did you have to travel to your client? You could have done it by Zoom or Teams. But the same arguments, I think, will start to creep in. I haven't seen any yet, but I fully expect those arguments to creep in. And that is really where Andrew, I think one of the points that Andrew makes towards the end of the billable hour. So where do we go from here? What is the future? Well, AI is likely to be embedded in everything we do, both in costs and in our legal work, and indeed in our daily lives, if it's insofar as it's not already. So think of email, think of e-disclosure, new concepts back in the day, but entirely ordinary now. Bundling, for example, a new concept, electronic bundles back before COVID, now entirely ordinary and a pain in the backside when you get a bundle that is not an electronic bundle. There's likely to be specialist models of AI specific to certain areas of law, so vertical AI models, and the future probably looks like a hybrid with AI on one side and the lawyer on the other. I expect there to be disclosure, something implemented soon for disclosure of AI use in submissions, and of course there may well be with those clients who perhaps are sophisticated clients, they may say, well, I don't agree to pay the money that you would have charged 3 years ago because now you have the benefit of AI and I don't expect to pay what you are asking. So they will demand faster and cheaper services, and firms are going to have to keep up with that. So embedded generally and used universally is probably where I see it going. Andrew, any words from you?
Yeah, I think we're at the beginning of what is going to be a long journey, but it's going to change dramatically. There's a lot of questions in the comments about, what effect will this have on how we can charge and time and so on. You've got to look at it this way. Your client isn't paying you for the time you spend on the case. That's donkey work. Your client is paying you for your expertise and the value of your decades worth of experience. And that is the short answer to it. How you actually get to a figure which marries up expertise and years of experience, that's a different question. But I think that's the way we're going. Now, Paul, we're coming up to the last 2 minutes. I think we're into concluding remarks. They've been a very lively audience, and that's been absolutely great. Thank you so much, guys, for chipping in like this. What I would leave you with before I pass the baton over to Paul is this. We're going to send you the slides for this so you can chase up the references. I've also written a short book on AI, which is coming out on Amazon later this month. Because you've very kindly come to this seminar, I'm going to send you a free copy of it. When you get it, I would be very grateful for any comments, criticism, or other remarks you want to offer. Just send them into Chambers in the usual way, and they will be very keenly read by myself. We will also probably return to AI later in the year and have another seminar. And of course, anybody who's got any suggestions as to what that might cover, and by all means send them in too. But what I will leave you with before I pass the baton over to Paul for his final remarks is simply this. This is a rabbit hole which has no bottom, but it's one you've got to go down if you want to remain a lawyer in practice in the next 3 to 5 years, because it's coming. It's not only coming, it's here now, and it's affecting what we're doing. Paul, over to yourself.
Yeah, last word from me. Recognize the ethical and regulatory issues, but don't let that put you off playing around with it for what it is, which is an extremely useful tool, which will be able to make your life both legally and domestically better, and certainly a lot more fun, because it's not just all serious. The second and last point that I'd make is read Andrew's book, because I have it, fortunately, and it is absolutely excellent. And that is not him asking me to plug it. It is really good fun. So, and that will also, help you move things along from an AI perspective, and hopefully in your professional lives.
Brilliant. Well, thanks very much, everyone, and see you again on the next occasion. Cheerio.
Thank you.